I want to come to you, Satyapal Jain, first. The general principle in this country is bail and not jail. Umar Khalid and Sharjeel, Imam and others have already spent 5 years in jail without even a basic trial beginning. Is that not a miscarriage of justice?
Let's understand the total working of the criminal system. I do not agree at all that simply because they have been denied bail by two courts. First, the special judge, who is at the level of the district judge, and their appeals have been dismissed by the High Court. Does it mean that no law has been violated? There is no right to protest. If you see the order passed by the High Court today, which is a very detailed order, you have read 2, 3, 4 sentences, Mr. Azdi, from the judgment. The court has discussed each and everything, all arguments raised by both the sides. I do not agree that bail is the rule and jail is the exception. If you accept that, then everybody should come out on bail. Nobody should be in jail. Why should have lakhs and lakhs of people who are there in jail? These are the general principles. Criminal cases, maybe bail, maybe conviction, maybe parole, they go on the facts of each and every case. And let's not forget, it is the courts, two courts, which have denied them the bail. First the district judge, special court, then the High Court. And they have given detailed reason for that purpose. If you go through the judgment, each and every argument has been discussed. There are very serious allegations against them. Allegation of IPC, Prevention of Damage to the Public Property Act, Arms Act, Unlawful Activities Act, and so many things which I will not like to read because that may take a lot of time. The judgment is a well-reasoned judgment. Judicial process gives you inherent power. First, they dismiss the special judge, they come to High Court. Now, if they feel that High Court has not done justice to them, if they are of that opinion, they have every right to go to Supreme Court. I don't think there is anything we can attribute motive either to the court or to anybody else. It's a detailed order which, according to me, to my knowledge of the criminal law, it's a perfectly valid order.
The same, let Sanjay Hegde respond to Satyapal Jain's initial remarks. Sanjay Hegde, according to Satyapal Jain, this is a detailed, well-reasoned order. Umar Khalid and Sharjeel Imam have gone to other lower courts as well for bail in the past, and their applications have been denied. In the Umar Khalid's case, he even withdrew his bail application from the Supreme Court. How do you respond to what you've just heard, that this, according to Satyapal Jain, there is no politics involved here? They have gone strictly by the law.
Well, men and women of the law do know that you can write a detailed judgment and still be wrong. That is why we have appellate courts and we have larger benches. Now, the point here is bail has been denied on a technical reading of the UAPA, the sections granting which govern bail. The UAPA has a section which says that the judge must prima facie be satisfied that you are not guilty of the offense, and it also says that you are unlikely to repeat it again. Now, that section was interpreted by the Supreme Court in a case from J&K called Watali. Watali sort of closed the door on interpretation, made it so strict that bail was almost impossible to get. That was in 2019. 2021, the Supreme Court watered down Watali. What the Delhi High Court has done is to go by Watali, which is a 2019 judgment, and say that the 2021 judgment is distinguishable on facts. Then, as far as the merits of the case goes, the court has simply not said that we cannot get into it because we cannot conduct a mini trial at this stage of granting bail. What the court has basically done is to turn a Nelson's eye to the long period of incarceration. It is also to the fact that others have got bail, and has simply agreed with the prosecution that this is a matter of national security. Now, you can be secure in the peace of the graveyard, but the noisy discourse of the public square cannot be chilled by simply putting people in jail and throwing away the key.
Okay, you're saying the long period of incarceration, of being in jail for 5 years without even a trial starting, should have been reason enough to grant them bail. Satyapal Jain, respond to that, because that is really those who are saying that Umar Khalid and Sharjeel Imam should be released are saying, look, are they flight risks? Can they tamper with the case? Why should they be denied bail in a case like this, which for 5 years has not even reached the trial stage yet? Others who have been similarly charged in the same case have been granted bail. And there is still no direct evidence of the specific role of an Umar Khalid, for example, in the Delhi riots conspiracy. There is a charge sheet, but even the trial has not begun. Why not allow them bail till the trial starts?
See,
They
I
are
have
not
to.
terrorists. Are you calling them terrorists just simply because they have been charged under UAPA?
Let's be clear about two things. Number one, first, the issue of long custody or how much time have you spent in jail during trial or otherwise is one of the factors which have to be taken into consideration. This is not the only factor that since there is a long custody, so therefore you should be granted bail. This is one of the considerations. Number two, the power to assess the facts, law, arguments is not either with me or Mr. Sanjay Hegde or with you. This power has been given by the Constitution to the courts. And the present case, it is two courts. First the special judge and then the High Court, which has recorded reasons why the bail should not be granted. It's wrong. I'm not saying simply because you have not been given the bail, somebody may say that he's a terrorist. No. All that trial will prove ultimately.
So how often do special courts, sir, how often do
case,
special courts and high courts grant bail in a UAPA case? Isn't
yes,
part of
that
the,
all
how
depends.
often do you see special courts or high courts granting bail in UAPA case? It means I arrest you under UAPA, you remain in jail even as the trial will take years.
See, all the special acts, maybe PMLA, maybe SFI, maybe Unlawful Prevention Act, they have been enacted by Parliament. They have not been enacted by any particular government. They have been enacted by the Parliament of India. And Parliament of India has laid down certain conditions, keeping in view the gravity of the situation and the situation where the law has to be applied. So when it is the law of the land, the courts are applying the law of the land and they are passing the detailed order. And if they are aggrieved, they have a right to go to Supreme Court. He's rightly said there is a remedy of appeal. But we cannot say that simply because it's not to my liking. Therefore, I say no, this should not have been done, that should not have been done. That is the discretion of the judicial officer. Both are judicial officers.
Okay.
The third was also judicial officer. If you are not satisfied, go to Supreme Court. Supreme Court has in many cases been reversing the order passed by the trial courts.
You know, but as a result, a person spends years in jail. Sanjay Hegde, a final word on that, that eventually there is the Supreme Court and therefore both Sharjeel and Umar Khalid and others will have to try their luck in a Supreme Court. To attribute political motives at this stage, according to Satyapal Jain, would be unfair. That this case, because it's politically sensitive, hence they are being put in jail.
Who's attributing political motives? We are only speaking of the lack of proportionality and the overdose of punishment. You see, I too had been a prosecutor. And when I used to appear before Justice Katju, if I over-argued on behalf of the prosecution, he would remind me that the prosecutor's duty is to the court to be absolutely fair. And he would just tell me in Hindi, "Bache ki jaan loge kya?" So this is exactly what has happened. You may have started on a prosecution which you did not know where it would culminate. You wrote a 3,000-page charge sheet. You've got 400 odd witnesses. You can't say that I will lock you up till the cows come home and till your trial is completed. This case is now an international cause célèbre. We are being judged on what our courts deliver.
Okay.
And we do not judge the judges alone. We judge the bar as well.
See, I like to tell
I
Mr.
want to
Sanjay
leave it there,
Hegde,
Sanjay Hegde.
Article 14 is
And,
not available
Satyapal-
in the criminal matters.
Yes.
Article 14 is not available in criminal matters. Whether to grant bail to one or deny to other is the judicial discretion, which has been exercised in a very judicial manner. And if you are aggrieved, go to the Supreme
Sir-
Court.